Welcome, everyone. This is meeting number 71 of the Standing Committee on Health, and we're going to continue our study on the legislation pursuant to order of reference of Thursday, June the 8th, 2017, on Bill C-45. Just a couple of little housekeeping things I want to cover. We're scheduled today to be here from 3:30 to 5:30, tomorrow from 9 until 6, Wednesday from 1 until 6, and Thursday from 9 until 6 if we haven't completed. There is a little glitch, and that is we've asked for televised sessions, but we can't get a room for televised sessions for Thursday. But if we get closer, we'll still try to get it, but we may not have a televised session. As we go through the clause by clause, we have agreed that we will have a 5-minute limit per party to discuss proposed amendments. And we have 3 clocks here for each party, so we'll make sure that everybody fits in the time as appropriate. Just one other issue. There's quite a few clauses that have no proposed amendments at the moment, and I may try to group them together, but if anybody wants to talk about a particular clause, don't hesitate to raise it. Yes.
Mr. Chair, thank you. I have a motion, and the motion concerns the issue at hand, and as such, I believe it's admissible. And I wonder if you would just hear me at this time. When the Liberal government first introduced C-45, they presented 3 central goals that this legislation would achieve. The bill would propose to protect youth, regulate and legalize the marijuana industry in order to reduce illicit activity, and reduce the burden on the judicial system. I'd like to make it clear that Bill C-45 will accomplish none of these motions, these goals. This bill will allow youth to possess up to 5 grams of dried marijuana and permit the growth and cultivation of marijuana in the home. I'm not in favor of criminalizing youth for the possession of marijuana. However, giving youth free rein to possess as of age 12 will cause immense mental and social harm to our younger generations. This will not protect our youth and certainly not protect our kids. This bill also will have little effect on the illicit markets, as it does not cover the entire scope of marijuana products, and it grows homegrown. Homegrown creates the ideal environment for organized crime to thrive in our communities, and many witnesses have stated that C-45 will reduce the size of the black market is simply naive. Several witnesses stated that the criminal charges in Bill C-45 are in fact more severe than the status quo. This bill proposes that growing 4 plants is legal, but if you grow 5, you are a criminal. Or having a plant that is 99 centimeters tall is legal, but if it's 100 centimeters tall, you are a criminal. With more severe charges and with an increased number of smaller charges, often left up to the discretion of the officer, the number of judicial cases will only increase. In fact, witnesses clearly stated that this legislation will put even more pressure on our justice system. And I attested to that, I think, at the last meeting, what I was informed with my sons, who are indeed also police officers. This is a fundamentally flawed piece of legislation that will not protect our youth, will not eliminate organized crime, and will only increase the burden on both the judiciary and law enforcement officials in our country. With no education program in place, and with less than a year to go until the arbitrary date, far less than a year to go before the date of July 1st, 2018, I, along with my conservative colleagues, move that this bill proceed no further through the legislative process.
Through. Mr. Oliver?
Sure, I would move that the debate do now be adjourned.
Okay. All in favor of the motion to adjourn debate?
We have a recorded vote?
No, yes, okay, we never recorded votes. Mr. Clerk?
Monsieur Ayoub? Mr. Olson? Yes. Mr. McKinnon? Mr. Oliver? Ms. Sidhu? Ms. Gladue?
This is the motion to adjourn the debate? No.
Mr. Van Kesteren?
No.
Mr. Weber, Mr. Davies.
Mr. Ayub, you,
I thought that was the opposition, so I'm...
would you like to change your vote? Is
Yes.
what we're saying, yes.
To say yes, please. Thank you.
Yeas 5, yeas 5, nays 4.
Motion passed. Now, I want to go back to my introduction for the meeting. We have some guests today. Yes, Mr. Davies?
Sorry, Mr. Chair, I don't want to hold things up. I don't have a motion, but I just want to clarify a couple of things. First off, I understand that there are a number of sections of the bill that don't have amendments. So I would suggest that where you can move in groups for amendments, that where nobody has any amendment proposed, that you do so. I suppose subject to any of my colleagues, if they really want to discuss a particular section, they can. But I note the Conservatives have put in no motion, no amendments. The NDP has approximately, actually we have what are effectively 11 different amendments. They're expressed in 37 different places because 3 of our amendments are repeated. And after I introduce those amendments a few times, I won't belabor the point or repeat the arguments because my colleagues will start seeing what the rationale is. And the other point I was just going to make is that the motion that was adopted was that the chair reserved the discretion to limit debate to 5 minutes. It wasn't an automatic 5 minute. And the way you express it at the beginning of this meeting was that people would be limited to 5 minutes. That is not what the motion was. And what I would suggest is that you, of course, keep the discretion to do that. If you feel that any party is abusing that privilege, or if debate has gone on far too long on one amendment, then by all means exercise that. But I don't think we should start off with a clock of 5 minutes on each amendment, particularly since some of my amendments, they may take a little bit more than 5 minutes to introduce at the beginning. But then, as I've said, once they get repetitive, I won't repeat that. That would be my suggestion, Mr. Chair.
All right. Thanks very much. I know we're here to, I'd like to just introduce our guests before we go any further. We have guests here to help us, and I want to introduce them before we go any further. Then we're going to go to Dr. Elson. But from the Department of Health, we have John Clare, Director, Cannabis Legalization and Regulation Branch. Thanks very much for coming. From the Department of Justice, we have Carol Moranse, Director General and Senior General Counsel, Criminal Law Policy Section. Paul St. Denis, Senior Counsel, Criminal Law Policy Section. Diane LaBelle, General Counsel, Health Canada. And from the Department of Public Safety and Emergency Preparedness, Rachel Huggins, Manager, Policy and Development, Serious and Organized Crime Strategy Division, Community Safety. And we have Michael Holmes with us as well to help us with any questions we have as far as legal issues. And
Mr. Costin was added at the last minute. He's from the
Mr. Costa, Eric Costa has also been added to the list, so welcome. We also have additional legislative clerks, and we have lots of, our analysts are here to help us. So as we proceed through this marathon clause by clause, we have lots of help. So now, Dr. Elson, you are on our list. Did you want to?
Withdrawn.
Okay. Ms. Gladue, you're on our list.
Thank you, Chair. I would like to ask for a recorded vote on each clause as we go forward. I mean, we've been clear that we're opposed to the legalization of marijuana, and so as my colleague said, we're not bringing any amendments. It would be hypocritical for us to pretend to try to fix a bill that we wish didn't exist. That said, I think I was very engaged during the testimonies that we heard, pointing out the flaws in the bill, and I would continue to do that. But if we could have a recorded vote, I would appreciate it.
All right. So we will, does that have to come to a vote?
Well, I think it would be good to confirm with them.
Pardon?
I think it would be good to confirm with them because you.
All right, that's a motion, really, a motion to have recorded votes on all clauses. So we have a motion on the floor to deal with every clause with a recorded vote. So I'm going to, is there any debate on that? Mr. Davies?
Yeah, I'm wondering if that's really necessary on a bill of this length. You know, it's over 100 pages, and I can't remember how many clauses, almost 200 clauses, and I think I respect very much the right of my colleagues in the Conservative Party to state, unqualifiably their opposition to the bill, but I don't know if that's necessary to do that in the form of slowing down this process so much that we have to do that with every single section of the bill. So, I'm just wondering, I think that Ms. Gladue and others will make their position very abundantly clear throughout the bill. So I'm just wondering, it seems to be a rather time-consuming and unnecessary way to achieve, I think, her objective to slow this down. So I would oppose having a recorded vote for every single section. And I would just simply ask that maybe a representative of the Conservative Party at each section take the floor and express their opposition to that section.
I'm advised that at any time, a member can ask for a recorded vote, but a carte blanche for all the clauses is not in order. So, but we'll start and see how it goes. But the Conservative Party has really registered its position. I mean, nobody's misunderstands your position. So, all right. So we're going to start our clause by clause. And I'm going to start with, if I can, clause 2 through 6.
To say that clause 1 is postponed.
Clause 1 is postponed. We'll come back to that. That's the short title. We always come back to that at the end. But we're going to do clause 2 through 6. I see no amendments to it. Is it the will of the committee to pass those unamended? All in favor? All opposed? All right, clause 2 through 6 are approved. Now, in clause 7, we have an NDP motion, and I wonder if one of the NDP members would like to elaborate on it.
One of the NDP members would be delighted, Mr. Chair. So briefly, colleagues, this amendment would propose to add another provision to the purposes section of the bill, a new letter H, which would read that the purpose of this act is to protect public health and public safety, and in particular to, and here are the new words, recognize that criminal prohibitions on certain activities in relation to cannabis may have a negative impact on social determinants of health. For decades, evidence has been mounting that the so-called war on drugs has been a clear failure from a variety of perspectives, but particularly from a public health perspective. New Democrats have long understood that cannabis use isn't a moral failing or an issue of character, and that its criminal prohibition has, in most contexts, some would argue in all contexts, been more harmful than the substance itself. I think most tellingly, colleagues, we heard a lot of evidence in this committee about discretion being applied by police officers in enforcing this act and in applying penalties. And I think adding this purpose will serve as a guidepost to those officers in exercising their discretion. We heard of evidence from officers that said, and from I think the department officials, that there's discretion in terms of giving tickets or sometimes arresting. There's sometimes proceeding by summary conviction, sometimes by indictment. And I think that having a clear statement of purpose in this bill that recognizes that criminal prohibitions in respect to cannabis can have a negative impact on social determinants of health will help those officers and the people charged with administering this bill in exercising that discretion. I want to just give a couple of quotes to the committee. Dr. Eileen Davila, the medical officer of health with the Toronto Public Health, said that criminalization of cannabis use and possession impacts social determinants of health, such as access to employment and housing. Given that cannabis possession will soon be made lawful in Canada, I urge you to immediately decriminalize the possession of non-medical cannabis for personal use. That, of course, the latter sentence speaks to a different issue, of course, but her main sentence, I think, is clear. Michael DeViller, the assistant professor at McMaster University, said that issuing of more criminal records will continue to have a devastating impact on the social determinants of health of mostly young Canadians. Prohibition also poses a problem for those who are dependent on cannabis and are seeking treatment to improve their lives. In my experience as a counselor, I have never encountered a patient who was helped by a criminal record. It actually impeded their efforts. Kirk Tusaw said, public health isn't just about the health consequences or benefits of using a particular substance. Public health also includes considerations of undue and unnecessary criminalization of people, use of the courts, use of the legal regime, misuse of police resources, distrust between the police, and all of those other things are amplified by taking some sort of restrictive approach to people accessing relatively safe products like cannabis. And finally, I just want to quote our two ministers that came. The Minister of Health, Honourable Petipa-Taylor, said, "Protecting the health and safety of Canadians is a priority of our government and the focus of this bill. Canadians use cannabis at some of the highest rates in the world, and decades of criminal prohibition have not reduced these rates. In fact, cannabis has become the most commonly used illegal substance in Canada. Our youth have the highest prevalence of cannabis use when compared with peers in other developed countries. This clearly shows that the current approach to cannabis is not working. To echo what my colleagues have indicated, the evidence is clear that prohibition, the status quo, is just not working." And finally, Mr. Chair, Honourable Jody Wilson-Raybould, the Minister of Justice, said this: "There is a broad consensus among Canadians that our current approach to cannabis is not working. Our system of criminal prohibition fosters an environment where organized crime reaps billions of dollars in profits from its sale, where thousands of Canadians each year end up with criminal records for non-violent cannabis offences, where cannabis is not being kept out of the hands of young people." So, in conclusion, Mr. Chair, I think that adding a clear purpose that states that one of the purposes of this act is to recognize that criminal prohibitions on certain activities in relation to cannabis may have a negative impact on social determinants of health is not only an absolutely profoundly accurate statement, it's one borne by the evidence this committee heard, it's one that was reinforced by the Minister of Health and Minister of Justice, and also will have the, I think, the very helpful impact of helping those entrusted and charged with enforcing this legislation in the future to remind them that wherever possible, to not use a criminal approach to cannabis is preferable and should be avoided at all costs, given the negative health consequences of criminalization on our population, particularly on young people. Thank you, Mr. Chair.
Thank you. You're right on time. Mr. McKinnon.
Thank you, Chair. First of all, I'd like to thank Mr. Davies. I agree with him on many of aspects of what he has said. You know, the war on drugs is a failure of prohibition. And I'd like to compliment Mr. Davies on the enthusiasm and care and concern with which he has addressed this file. Having said that, I think that the intent, the purpose of this bill is already very well stated. It is inherent in the existing purpose. And in that respect, I think that Mr. Davies' amendment is redundant and will, in the end, add no value.
Any other debate? Okay. Yes, Mr. Davies?
Call for a recorded vote on this amendment, please.
Calling for a vote on the amendment.
Monsieur Ayoub. Mr. Yolson. Mr. McKinnon. Mr. Oliver. Ms. Sidhu. Ms. Gladue.
No.
Mr. Van Kesteren. Mr. Weber. Mr. Davies.
Yes.
Well, I declare the amendment negatived. Will the clause 7 carry as originally drafted? All in favor? All opposed? Clause carried. All right, now we go on to Clause 8, and we have an amendment here from the NDP, and I have a note here from the legislative clerk. It says, if adopted, the NDP 25 is also adopted as a consequential impact, if that NDP 2 is carried. So would you like to introduce it, Mr. Davies?
Thank you, Mr. Chair. Yes, so Section 8 of the bill is the bill that sets out a limit of Canadians possessing no more than 30 grams of dried cannabis in public. And the purpose of my amendment would be to delete that so that there is not a limit of 30 grams possession, distinguishing a Canadian who's not a criminal from one who is a criminal. The rationale for this, again, comes largely from the evidence and I think from logic as well. It's completely arbitrary to restrict possession to 30 grams. So this legislation would say that someone in public who has 29 grams of cannabis is a law-abiding citizen, and someone who's got 31 grams of cannabis is a criminal, who is subject to a jail sentence of up to 5 years. There's no clear policy goal satisfied by that distinction. I don't think anybody in this room, frankly anybody in the country, could make a compelling argument that someone with 31 grams of cannabis in public is doing anything inherently more criminal than someone with 29 grams. This measure, even worse, will continue to impose all of the harms of criminalization that the purposes of this bill that the Liberal government just passed claims to ameliorate or to enforce. We know that taking up police resources, we know that clogging up our courts, we know that criminalizing Canadians for simply possessing cannabis in amounts that are clearly for personal use or for use among their friends serves no valid purpose and in fact does a great deal of harm. It costs our society billions of dollars. It makes our court time valuable so that more serious crimes get shifted into the future. In some cases, people facing serious crimes don't even have a trial at all because of the Jordan principle, because our courts are clogged up with minor, petty cannabis offenses. We don't treat alcohol or tobacco this way. We don't criminalize adult possession of amounts of alcohol because that is inconsistent with the concept of a legalized market. Anyone in this room could back a van up to a liquor store and fill the van up with cases of scotch. Cases and cases and cases of scotch. In fact, you could fill up a semi-trailer with cases of scotch and drive away, and that's not an offense in this country. And we heard evidence, it's clear, that alcohol and tobacco are clearly more dangerous to health than cannabis is. Nobody even disputes that anymore who looks at the evidence. Yet this legislation says that if you have 31 grams of cannabis in public, you're a criminal. It makes no sense. Now, I want to just talk briefly about a theme, because I think it's important for Canadians. This may be a distinction without a difference. But Mr. Trudeau and the Liberals campaigned last election on legalizing cannabis. This bill has more sections of criminalization of cannabis than exist in the current criminal code. It does not legalize cannabis. It makes it less illegal. So it is still a criminal offense punishable by jail to have 31 grams or more in your possession. That's not legalization. We could argue it's better than the status quo, and I would probably agree with that, but it's not legalization. Now, there is no argument that we heard in 5 days of hearing and some 90 witnesses that cogently explained why 30 grams exists, why that number was chosen, and why anybody with more than that or less than that is a criminal or not. Neil Boyd testified that the idea that we would pass legislation that would retain a criminal offense of possession of cannabis seems to me to be inconsistent with at least part of the logic of this act. I know that the Prime Minister has repeatedly said it's about eliminating the black market and reducing access, but part of it is also about recognizing that people who have used cannabis or use cannabis do not deserve the label of criminal. Kirk Tousaw said, Bill C-45 contemplates criminal penalties being applied to adult Canadians who possess more than 30 grams of cannabis or grow more than 400 centimeter plants per household. These are completely arbitrary numbers. These criminal restrictions are decidedly unlike the way our country regulates alcohol, a vastly and inarguably more dangerous substance than cannabis. At this moment in Canada, a 19-year-old can walk into a liquor store and purchase enough alcohol to kill that person and all that person's friends and acquaintances. Indeed, there's enough alcohol in one bottle of vodka to kill the consumer. And we don't tell that person that they can't have 40 bottles of it. Paul Renault, the Communications Director of Educators for Sensible Drug Policy, said, "Youth cannot be criminalized for alcohol possession. What sense does it make to criminalize anybody for cannabis?" So, Mr. Chair, I'll conclude just by saying, if truly we believe that the Minister of Justice and the Minister of Health, that prohibition doesn't work, then why are we persisting with provisions in the bill that continue to prohibit based on an arbitrary number that serves absolutely no logical purpose whatsoever, other than just to say Canadians can have 30 grams or under, but not more, for no logical, compelling, science-based reason. I'm going to conclude by saying I've heard this government talk repeatedly, and I congratulate them for claiming to take and taking in some cases an evidence-based approach to legislation. This is not an evidence-based approach to legislation. This is an arbitrary approach to legislation with no basis in science or fact. So I'm going to ask my colleagues to support the removal of the limit of 30 grams of dried cannabis and start treating adults in this country like adults. Certainly adults can determine how much cannabis they want to have in their possession. And there's other sections in this act that control trafficking and sale and production and distribution that will completely take care of any issue around those concepts. And let's let Canadians start having the mature decision to be able to decide how much cannabis they want to have. My final point is this. In terms of medicinal cannabis or people that are using cannabis for other reasons, someone may decide to go on a 2-month trip or a 1-month trip across Canada. And when we get to the cultivation parts, we'll see that Canadians can grow their own. Ironically, you can have 4 plants. You might be in possession of 160 grams of cannabis in your house. That's okay. But you can't have more than 30 grams in public. Well, what if someone wants to go on a trip and take 50 grams of cannabis with them for a month-long trip across Canada? They're criminals? What if someone's moving? So you move apartments and you take down your plants, you harvest your plants, you've got 100 grams. You can't, what do? You make 3 trips? I mean, this is an absurd limit. It's arbitrary and absurd. And the harm and the amount of police time that will be taken in having to continue to police what is essentially a criminalized approach to possession of cannabis in this country is as wrong after this bill as it is before the bill. So if my colleagues on the Liberal side really believe in the purposes of this bill, that we want to deter illicit activities in relation to cannabis, reduce the burden on the criminal justice system, protect the health of young persons, then why don't we come up with evidence-based provisions in this act and make this act consistent with those purposes? Because this 30-gram limit does not meet that test now.
Thanks very much. Ms. Gladue.
Thank you, Chair. I think we heard a lot of testimony. I was specifically interested in this possession amount because I was concerned that that's between 60 and 90 joints. And we did get testimony from Colorado and Washington that that's the limit that they chose, 30 grams, and the other jurisdictions that have legalized chose that. Now, within the bill, there is provision between 30 and 50 grams for a ticketed offense or some non-criminal intent, which would take you up to 100, 150 joints. And I seriously think, since trafficking is still a criminal offense, you have to really watch where you get from personal possession into an amount that you would be then tempted to traffic to others. So 30 grams certainly is too much, but I accept it based on the evidence we heard.
Mr. Oliver.
Yes, I was just going to, I think as Mr. Davies said, this topic comes up several times, so I thought maybe a number of us will jump in and have the conversation about it now, so that rather than repeating things as each time it comes up. So now might be a good time to have that discussion. So I guess, as Ms. Gladue said, both Colorado and Washington have set, and we've used them, I think, as good models of how to carefully and thoughtfully go forward, particularly in the first phase of introduction of what's quite a significant social change for Canada and, in the Act. So these are their limits, metrified, if I can say it that way. Theirs are a bit different because they were in ounces, but it is metric. The second thing is, it isn't you're over and you get 5 years in jail. These are officers have a choice to ticket and seize, which is very different and doesn't have the same consequence, or they can do a summarily, or they can charge with an indictable offense. So there's a range open, because the goal of the legislation in this phase, I believe, is to stop organized crime and to deter the activity of organized crime. And we heard from many of the witnesses that it was going to be very difficult for us to step in and deter organized crime in this space. So increasing that, having some kind of consequence, I think is important. Recognizing that if somebody's caught with 30 to 50 grams, it can be ticketed. If it's simply somebody caught, as Mr. Davies said, moving across from one province to another for a month's holiday, that would be ticketable at the officer's discretion. I think those are sort of important considerations. And the other piece with organized crime is at some point we do need to, I mean, this is not about opening up recreational marijuana. It's not about choice for consumers. It's not about promoting marijuana. It's about restricting youth to access. It's about deterring organized crime, and it's about safe production. People can have, as Mr. Davies said, unlimited amounts in their home. It's simply if they're caught, if they're in public with it. And I think the issue that stopping organized crime is that people carrying amounts over 30 or over 50 grams, you're starting to, that doesn't look like personal use in public, that looks like trafficking. So I think I don't think it's arbitrary. They've used guidelines from other jurisdictions. I think it's a conservative approach to introducing this particular topic, and those are the points that I wanted to raise in this one.
Okay, thanks very much. Mr. Van Kesteren.
Thank you, Chair. Mr. Davies makes a very valid argument. I must say that his argument is very sound. And I don't agree with that. I would take issue perhaps with a number of things stated. For instance, he says that there isn't a negative effect, but we've heard a witness say that youth right up until 25 there's very clear science that says that there may be very negative effects mentally. So there's just a whole lot of it. When I'm listening to this argument, I'm hearing just confusion. And I'm hearing a legislation that we're getting what we'd like to say, I'm a fisherman, we're getting into the weeds. And when we start to do that, we just start to see how entangled we become. I can't reiterate enough when I say that this is a bad idea. And I really believe that there are many on the Liberal side that know this is a bad idea as well, too. I think as we continue to debate this, and as we continue to go clause by clause, we repeatedly hear about the need to protect our youth, the need to put a stop to organized crime, how shallow an argument that is, and as a matter of fact, how inept it is, and the fact that it has no legs. So although I do agree with we either go into this all out, open the whole thing up, or we really start to look at what this legislation is actually is going to, what it is going to open up, which is Pandora's box. So although I agree with his argument, I disagree with the outcome of that, and so I certainly will be voting against this proposal.
Thank you very much. Mr. Ayoub.
Vous laissez le temps de prendre vos.
I'll just give you a moment to put your headsets on. Well, basically, we are hedging our bets to an extent. We don't have a polarized view. We're not against criminalization 100% with no constraints or decriminalization such as alcohol and tobacco, but we also agree with other arguments that there is a danger for the health of our youth, and that is our top priority, and that is highlighted in the title of this bill. So we do need some framework, some criteria. We want to put an end to the organized crime around marijuana, and we want to ensure that the black market is not 100% eliminated to as greater extent as possible. And then, at that point, we won't need legislation that is as severe. But in the meantime, between doing nothing and keeping the status quo, or on the other hand, opening up the doors wide, I think there's a balance to be struck, and that is what we are trying to achieve and what we're doing here. That is a certain quantity of cannabis so that young people don't clog up the courts by using 5 grams. It's not what we're advocating they consume, but we just want them to be informed and educated, and the same applies for adults. 30 grams is a level of consumption for the average adult, from what I understand, is reasonable, and it's reasonable to possess that quantity, 30 grams, without having a criminal record, etc. Now, aside from that, there's production, trafficking, and that is also one of the goals of the legislation. But we're not going to, in a short space of time, a couple of months, a couple of years, fix this legal issue, because we'll have to come back to the legislation in a couple of years and review it based on the progress that we have made. So I think that we are striking a balance in our stance.
Being no further speakers, you used a lot of time, Mr. Davies, but go ahead for a short comment.
Just one last set of remarks. Mr. Van Kesteren said into the weeds. I think we should say into the weed, but he set me up for that. Just a few quick remarks. We are talking about people over 18, so this section does not talk about young people at all. We talked about Colorado and Washington being used as models. Well, we didn't use Colorado and Washington for models in several other very important respects. For instance, they legalized edibles, and this government didn't. So you can't really pick and choose. You can't really refer to other jurisdictions, say we use them as models, but only when it kind of suits your argument. The punishment section of this section is very clearly, the very first part is every person that contravenes subsection 1 is guilty of an indictable offense and is liable up to a term of imprisonment of not more than 5 years less a day. It then has summary conviction possibilities as well. So make no mistake, if you're caught with more than 30 grams, you are liable under this legislation to up to 5 years in jail. You may not get that the first time, I agree, with discretion, but you could. The thing about trafficking, the thing about making the assumption that if the argument is if someone has 40 grams of cannabis, we're going to make the assumption, oh, they must be traffickers. That's actually not consistent with the way the law is now. You can't make an assumption that just because someone has a certain amount of cannabis that they're going to do something. That's why the law currently requires other evidence of trafficking, like scales, baggies, other accoutrements of trafficking. If you've got a trunk full of scotch, nobody assumes that you're going to go sell it on the black market just because you have a lot of scotch. So that I would say leave the law to the discretion of the courts and judges on that. I agree, Mr. Kesteren, I want to be clear. Cannabis is not without health impacts, for sure. But the evidence was very clear that it is not as harmful as alcohol or tobacco. There's no known overdose limit for cannabis, and it's not a carcinogen like tobacco is. So that's why the argument, in my view, is that cannabis should be proportionally regulated as tobacco and alcohol. And we don't have 5-year jail terms from having 50 cartons of cigarettes in your trunk. You can go to the store and you can buy as many cartons of cigarettes as you want. You can buy as much alcohol as you want. So why would we put a limit on cannabis? And finally, the thing is that if Canadians if Canadians find that there's arbitrary elements in this law, then they will disrespect the law and they will ignore the law, just as they have been doing for decades. So unless you have a good argument to tell an adult Canadian why they can't have 35 grams as opposed to 25, and one can go to jail for 5 years and one person is a law-abiding citizen, you're running the risk that people will flout the law and disrespect it. And that's really what's happened. So if there's no rational basis to 30 grams, then we shouldn't be restricting adults that way. And if someone's caught
You
with
have-
a
you have
lot
to
of
wind it up.
cannabis,
You have to
I will
wind
wind it up. If someone's caught with a lot of cannabis, Mr. Speaker, if there's other evidence of trafficking, then charge them under that bill. But don't make that assumption simply from the amount of cannabis they have.
All right, thanks very much. Now, so I'm going to call for a vote on NDP 2. All in favor?
Vote, please.
For the vote? Mr. Clerk?
Monsieur Ayoub. Mr. Yolfson.
No.
Mr. McKinnon.
No.
Mr. Oliver. No. Ms. Sidhu.
No.
Ms. Gladue.
No.
Mr. Van Kesteren. Mr. Weber. Mr. Davies.
Yes.
Yes pour 1, nays contre 8.
All right, that vote is negative. Now we're going to go to the Green Party amendment, PV1. And any discussion or debate on PV1? Ms. Gladue?
Yes, this is where she proposes to increase the amount that a young person could have from 5 grams, which is already the wrong message. 0 is the right amount for a young person to have, up to 30 grams, which is just unbelievable. So I would definitely be opposed.
Ms. Sidhu?
Yes, Mr. Chair. Supporting that amendment, I think it's not consistent with the government's response because government doesn't want to convey the message young person that cannabis use is acceptable, normal, or healthy behavior. I think it's not consistent.
All right, seeing no more comments, I'm going to call for a vote. All in favor of Amendment PV1? All in favor? All opposed? Amendment negative. So now, on Clause 8. All in favor of Clause 8 as originally written? Oh, is there no, I didn't turn it on. Thank you. Yeah, now we go to NDP 3. Excuse me, sorry about that, but if you could, pardon? No, it didn't. This is Clause 8. We're still in Clause 8.
Oh, pardon me.
I didn't turn the page. I apologize. So NDP 3, and a note to Chair, if adopted, NDP 4 cannot be moved if this one is adopted. So NDP 3, would you like to make a comment on that?
Yes, Mr.
But try to restrict it a little bit.
Well, Mr.
shorter.
Chair, this is the one where I would probably ask for a little bit of indulgence because this is the one that comes up repeatedly, and I'm not going to repeat the arguments when they come up.
You had quite a bit of indulgence, but go ahead.
Yeah, on different sections. Well, I'll speak for 5 minutes to every one of the other sections if that's better. I mean, this way it saves time. I speak for 10 minutes now, or I speak for 50 minutes.
Go
So
ahead.
that's the spirit of me offering that. The way I want to introduce this is this legislation has a number of sections that still retain a criminalized approach to cannabis with quite heavy criminal penalties and heavy jail sentences possible, in fact, up to 14 years. I've pointed out before that 14-year maximum sentences are similar to producing child pornography or leaving Canada to commit acts of terrorism. And yet, a 20-year-old in this bill could sell cannabis to a 17-year-old and potentially face a 14-year sentence. So, but from a broad philosophical point of view, I agree with the government in their general approach to legalize cannabis. I just want to point out that by retaining a prohibitionist model and retaining criminal sanctions for a whole host of offenses around cannabis, you're not legalizing cannabis. And so what I propose here, Mr. Chair, is I'm going to have 3 different types of amendments that every time a section comes up that has a jail term criminal sanction to it, I will move 1, 2, and 3. So the first type of motion that I will move, and that's what I'll move here first, is to replace the criminal framework with monetary penalties modeled on the Tobacco Act. So it still will retain the ability to impose a criminal sentence on the most severe or most repetitive type of commission of an offense. But it basically changes, just like it does under the Tobacco Act or under the Alcohol Act. But it generally more faithfully makes this legislation change a criminalized approach to cannabis to one that is more regulatory. The criminal framework created by this bill is inconsistent with a rational and evidence-based criminal justice policy, and I think will only serve to enhance or reduce the positive impacts of cannabis legalization. The penalties contained in Bill C-45 are drastically out of proportion with those currently applied to alcohol and tobacco offenses. And I think cannabis legalization should take a regulatory approach with significant fines for offenses rather than a criminal one. And again, one of the purposes of Bill C-45, as laid out in Section 7, is to reduce the burden on the criminal justice system in relation to cannabis. So penalties in the bill, I think, should be consistent with that stated intent. I will point out as well that a maximum penalty of 14 years imprisonment eliminates a judge's discretion to impose a conditional sentence. And we heard evidence that current sentencing ranges for cannabis offenses under prohibition are far shorter than the length proposed under legalization in Bill C-45. The Canadian Bar Association said, at present, sentences for cannabis offenses are not near the length proposed in Bill C-45, as even large-scale operations do not generally attract 14-year sentences. While some criminal sanctions might be appropriate for an offender distributing a large quantity of illicit cannabis, that will be the exception in a legalization regime. If cannabis is to be treated like tobacco or alcohol, penalties available should reflect those regimes. For tobacco, Section 220 allows a person to grow up to 15 kilograms of tobacco for personal use, with the same allowance for other adults on the farm or premises. Selling without a license brings a fine, and for default in paying the fine, up to 12 months imprisonment. The same is true for violating Section 220. Offenses for selling without paying duties carry penalties on indictment of up to 5 years, and on summary conviction up to 2 years. That's the Canadian Bar Association. John Conroy said that all indictable offenses should be abolished, leaving only summary conviction offenses and a maximum of 2 years less a day imprisonment for serious matters. There should be no imprisonment available for cannabis offenses, and the focus should be on monetary penalties for infractions and violations. Mr. Conroy said having the maximum of 14 years hybridized by indictment is frankly totally unrealistic in terms of what goes on the ground. Even in the Saskatchewan Court of Appeal, which is not known to be the most liberal court in the country, the range for trafficking, for example, is 12 to 18 months. Most sentences are up to 2 years. The conditional sentence order is the last step before having to put you actually in prison. And a 14-year maximum because of the 2012 amendments prevents a judge from doing that. Kirk Tusaw said, these criminal restrictions are decidedly unlike the way our country regulates alcohol. At this moment in Canada, a 19-year-old can walk into a liquor store and purchase enough alcohol to kill that person and all that person's friends and acquaintances. Similarly, there are virtually no restrictions on individual Canadians' rights to brew beer or make wine for their individual consumption. Given that reality, it's ludicrous, or to put it in legal terms, arbitrary, overbroad, and grossly disproportionate to allow Canadians to be arrested and caged for simply possessing an amount of cannabis or dealing with it in an illicit manner. There is no empirically, morally, or legally sound reason why cannabis should be treated more strictly than alcohol. And finally, Michael Spratt said that Bill C-45 is an unnecessarily complex piece of legislation that leaves intact the criminalization of marijuana in too many circumstances. He goes over the fact that an adult who possesses 30 grams of marijuana in public is a criminal, a youth who possesses more than 5 grams of marijuana is a criminal, an 18-year-old who passes a joint to their 17-year-old friend is a criminal, an adult who grows 5 marijuana plants is a criminal, and an adult who lets his 1-meter-tall marijuana plant grow an extra centimeter is a criminal. This continued criminalization is inconsistent with a rational and evidence-based criminal justice policy and will only serve to reduce some of the positive impacts of the bill. So in conclusion, Mr. Chair, my first range of amendments, and the one that will be put before my colleagues first, is to remove the jail sentences and replace them with monetary fines in this section. And as you'll see, the second type, if this is defeated, the second type of amendment will reduce the 14-year maximum sentences to 2 years less a day, so it'll retain the criminal and penal sanctions, but it'll put the sentencing into a more reasonable and frankly realistic sentencing range, which is the case in Canada today, and make all other offenses summary conviction only and strike out the indictable offense sections. And my third section, if that doesn't pass, is simply to reduce the 14-year maximum sentences wherever you see it with 9-year. And that's because any offense in the criminal code that carries a maximum of 10 years or more does not qualify for a conditional sentence order by a judge. And we want to restore that discretion to a judge. So, Mr. Chair, that's sort of the explanation of all of these amendments. I'll move the first amendment now, which would remove the jail sentences and replace them with monetary fines.
Thanks very much. Just
Thank you for your indulgence, Mr. Chair.
Thank you. Okay, Dr. Ayolfson.
All right, thank you, Mr. Chair. There is, I find some merit to what Mr. Davies says, but we were also advised by the jurisdictions that had it legalized to say, take it slowly, take this very slowly, and for one thing, not to go too far, do too much too soon. And in regards to an earlier comment about how we had campaigned on legalizing, we had campaigned on legalizing and strictly regulating. So that was part of it. We didn't just say the word legalizing. But one of the things that we want to get a hold of is the problem right now of trafficking. And trafficking, we have to set some limit on what is the difference between the amount you'd have for personal use and what is what might be considered for trafficking. This may be reviewed if this amount is causing problems in the future, but again, this is the amount advised by these jurisdictions that have legalized it, and therefore I'll be opposing this motion.
Thanks very much, Mr. Van Kesteren.
Thank you, Chair. I wonder if I could indulge with Mr. Davies. As I said, it's a great sound argument again. Why wouldn't you go all the way? Why wouldn't you just say that we need to remove all sentencing, except perhaps in case of trafficking? Like if you take this argument to its logical conclusion, and if marijuana should be something that should be freely accessible in society, and if people are adults, and if they choose to use it, why would we, and I mean that with all sincerity, could you maybe explain to me why we have any sentencing or any prison time or fine at all?
May I, Mr. Chair, respond briefly? Well, that's an excellent question, and one I think that was raised throughout the testimony. I think it's a fair characterization of the evidence we heard that cannabis is a similar product to tobacco and alcohol, and we should adopt a similar regulatory system to that. They're mind-altering substances. You don't want children to be using it. They all have health consequences of varying degrees, but ultimately, at the end of the day, we think that they're substances that adults should be able to choose in the comfort of their own homes to indulge in or not without attracting criminal sanction. And so that's why I'm really puzzled by this, that given the evidence we heard, and the Liberals heard the same evidence, that cannabis is less harmful than tobacco or alcohol in any range of measures, why would we be bringing in legislation that retains a much harsher, much heavier, criminalized approach to cannabis when we don't have that for tobacco and alcohol? Now, the reason that you need to have some, I think it's justified to have some regulatory controls around this is we do with tobacco and with alcohol as well, being controlled substances. The fact that we want to keep them out of the hands of children, the fact that we want to make sure the products are safe, and that production is controlled, and we don't want these substances to get into the hands of organized crime. I think that warrants and justifies a regulatory approach where there has to be some sanctions. The question is what are the appropriate sanctions? And as Dr. Ayolfson said, yeah, there need to be some consequences, but we're talking about possession. This is the possession section, not the trafficking section. And so the question is really, do you need a 5-year jail term? Is that really what we as parliamentarians want to say? You get caught with 90 grams of cannabis, We say the judgment in 2017 is that you're a criminal and you can go to jail for 5 years. There was no evidence before this committee that suggested that that was an appropriate response by anyone. And the Liberals, I can tell, are going to vote against this, but and they can do that. But what they can't do is they can't square that with the evidence we heard of this committee, which is that's completely out of whack with even the penalties given now under complete criminal prohibition, where you can traffic large amounts of cannabis and you'll get 2 years. But you can, under this act, possess 80 grams and get 5 years. So what I want to do is, I guess, find the proper regulatory system with proportionate responses so that we can legalize this substance. And I take Dr. Elson's point well that this does represent a change in culture, and moving with some caution, I think, is understandable. But it doesn't mean we should sit as parliamentarians and pass a bill that has criminal law provisions that are not based on the evidence, and that we all know will do more harm.
Okay, that's good. Good. Thanks very much. Now I see no further speakers on this, so I would like to bring this NDP3 to a vote. All in favor of NDP3? Yes. Okay, Mr. Clerk.
Monsieur Ayoub? Mr. Olson?
No.
Mr. McKinnon?
No.
Mr. Oliver? Ms. Sidhu? Ms. Gladue?
No.
Mr. Van Kesteren?
No.
Mr. Weber?
No.
Mr. Davies?
Yes.
Yeas pour 1, nays contre 8.
That amendment was negated, but it wasn't unanimous, so that's a consolation. Now we go to NDP 4.
Thank you, Mr.
5
Chair.
minutes.
I won't take as much for this now. I think, and I appreciate you finding the silver lining in every cloud.
Yeah.
So, Mr. Chair, this, in keeping with what I just said, so the second best amendment that I think we could make to this bill is, if we're not going to take a regulatory approach with fines, then I think at the very least we should make the criminalized part of this, the jail sentences, at least reasonable. And what this amendment would do would be to remove the indictable offense for possession, and it would leave the summary conviction, which would mean that any offense of the possession provisions of this bill would leave a person subject only to summary conviction with a maximum $5,000 fine and a maximum of 6 months in prison, or to both. And again, I want to make clear that's not my first choice, but given that it's the will of the majority of this committee not to move to a regulatory penal system and to maintain a criminalized one, then I will at least suggest that we remove indictable offenses from simple acts of possession of cannabis in this country.
Okay, seeing, yes, Mr. Ayoub.
Dans le même sens, puis je comprends bien l'intention.
I understand my colleague's intent, and I have respect for it. We don't want to repeat what has been said on this same Section 8. We need to have the means to work when quantities are large. 30 grams might not be a large amount, according to Mr. Davies.
What we're recommending under the legislation is to give the court an opportunity to impose penalties. And this is part of the legislation as it currently stands. So for that reason, I oppose the amendment.
Ms. Gladue.
Yes, thank you, Chair. I want to say that we did hear a lot of testimony that said for younger people that cannabis harm education is a better thing than punitive things, and there was a lot of support for the ticketed offense type summary conviction approach. But certainly, in light of all of the things that we hear, I wanted to correct what the member has said about there not being any harm with cannabis. He keeps comparing it to alcohol and tobacco. Well, tobacco is a harmful substance, and alcohol is a harmful substance, and cannabis is a harmful substance.
Thank you. Seeing no further names on the list, I'm going to call for a vote on NDP 4. Mr. Davies. Recorded vote.
Monsieur Ayoub. Mr. Yolson. Mr. McKinnon. Mr. Oliver.
No.
Ms. Sidhu. Ms. Gladue.
No.
Mr. Van Kesteren. Mr. Weber. Mr. Davies.
Yes.
Yes pour 1, nays contre 8, 8.
Amendment defeated. All right, now we go to shall Clause 8 carry? Oh, yeah.
Can I request a recorded vote for Clause 8?
Clause 8, shall Clause 8 carry?
I have an amendment to add section.
We're going to get to
8.1.
8.1.
That's the next clause?
Yes, that's the
Okay.
next one, yeah. So, well, Clause 8 carry. Mr. Clerk?
Monsieur Ayoub.
Oui.
Mr. Yolson.
Yes.
Mr. McKinnon.
Yes.
Mr. Oliver.
Yes.
Ms. Sidhu.
Yes.
Ms. Gladue.
No.
Mr. Van Kesteren. Mr. Weber.
No.
Mr. Davies.
Yes.
Yes pour 1, nays contre 8, 8.
Clause 8 is carried. Now we have a new Clause 8.1 proposed by Mr. McKinnon. Would you like to explain this?
Thank you, Chair. The purpose of this amendment is to bring the provisions of my private member bill C-224 to bear on this legislation. So as you may remember, Bill C-224, the Good Samaritan Drug Overdose Act, which received royal assent in May, and which passed all stages in both houses, I believe, unanimously, amended the Controlled Drugs and Substances Act to exempt from charges for simple possession and certain breaches of conditions and so forth for people who seek emergency medical or law enforcement assistance for themselves or another person in the event of an overdose. This is working, and it is an effective tool to help to stem the tide of death that pertains to overdoses in this country. However, should this bill pass and receive royal assent, cannabis would be removed from the scope of the Controlled Drugs and Substances Act, and the provisions of that act would no longer apply to cannabis, which means that those exemptions would no longer apply to cannabis. So what this amendment does is add into this section those self-same exclusions that were previously introduced and passed in the Controlled Drugs and Substances Act. We've also suggested some minor change. The wording of overdose is sometimes confusing to people. They don't know necessarily whether a particular medical situation is in fact an overdose, and so they're reluctant to make the call. So what this does is change the language to a what is it? A medical emergency, as opposed to using the word using the word overdose. And so I think this avoids for us a situation where someone who might be in a possession of marijuana, but in a circumstance where someone has been called in relation to, say, an opioid overdose, is subject to possession charges, which would detract from them would take from them the incentive to call for help, which is really what we want to do. We want to encourage people to call for help when help is needed. So I hope for support from the committee for this amendment.
This was your Good Samaritan bill, was it not?
Pardon me?
What was it? What did you call your bill? Good Samaritan?
Good Samaritan Drug Overdose Act,
Yeah.
C-224.
Okay, Ms. Gladue.
Thank you, Chair, and I want to commend my colleague opposite for the Good Samaritan bill. Certainly, it's something that is very important, and I think will save lives. That said, of course, no one has overdosed from cannabis, and I feel like this provision is sort of like putting cover-up on skin cancer, so I will be voting against.
Mr. Van Kesteren.
Thank you, Chair. And along the same lines, I wonder if we could get a word from our department. Is there a possibility that a person could OD from marijuana use?
I can speak to that, Mr. Chair. And to clarify the way the provision would work, it wouldn't be an exemption due to an overdose from cannabis. It would be any medical emergency for which someone dials 911. What the provision does is it exempts the person who makes the call or who is on the scene from any charge of possessing more than 30 grams of cannabis under the Cannabis Act.
So I'm just a little bit confused why this is being introduced. If there is no danger, maybe we can hear from the doctor or somebody. I mean, just need a little bit of clarification on this.
Mr. Davies, you're next, then we'll go to Mr. McKinnon. Or Dr. Elson's next. Mr. Davies.
Maybe I'll defer and let Mr. McKinnon respond to explain where it might help
I think
with my
that's a
question,
good
too.
idea. Mr. McKinnon, we're going to bump Dr. Elson for a minute. And we'll...
The problem we're trying to address here is in a situation where there is a drug overdose caused by whatever substance, or where there's an overdose of any kind. People are fearful to call for help because they're going to get in trouble, they fear. They're going to get arrested for holding whatever they're holding. And so they don't make the call. They will do things, they will do extraordinary things like take their friend out on the street and call for help anonymously. They'll take them anonymously to emergency and dump them off. And all of this takes time, and this is a situation where time is life. We can't save people from whatever their underlying demons are if they're dead. We can't cure dead people. So the purpose of this is to remove that fear of being apprehended for a possession charge in a situation where an overdose has occurred, and we want people desperately to make the call for help for that person or for themselves. We're not necessarily expecting a cannabis overdose in this circumstance, although we can get THC overdoses in the cases of some of the concentrates. We really just want to make sure that people call for help when there's a problem, and that they're not afraid of criminal consequences for possession to prevent them from making that call.
Dr. Elson.
Yes, thank you. And in regards to Mr. Van Kester's question, I just wanted to expand on this. The previous legislation, it said, it was it would exempt someone, as we've said, from being charged with possession for any drug that they had on them in an emergency. The problem is this bill, because it would take cannabis off the schedule, then if someone was carrying cannabis, and again, no, I am not aware of someone ever actually having overdosed on cannabis. But again, we have a substance that they might be carrying that under the old legislation they'd be covered and protected. But with this legislation, because it removes it from that schedule, they would no longer be protected, and they might think, well, Bob's turning blue, but I've got a quarter ounce of dope in my pocket. I don't know should I leave him in the street anonymously. This would correct that to say that there's not going to be any hesitation in making the correct call that can save a life.
Mr. Davies.
Well, just a few things. You can possess 30 grams in public, which is a little bit more than an ounce. There's 28 grams in an ounce, so it wouldn't be a quarter ounce. But I get the point. The point is, if someone had more than 30 grams, is that the intent, Mr. McKinnon, that if someone had, say, 60 grams on them and would otherwise be in violation of this legislation, but they wanted to call an emergency, say they were with someone else who was using opioids and they overdosed. And by the way, the evidence that we heard was there have been some cases of overdosing of THC of children after the introduction of edibles in Colorado, but there's never been a fatal. I think there's no fatality to that, is what I recollect, other than one person who apparently jumped off a bridge or something, and they claimed that had to do with. But Mr. McKinnon, I just want to clarify, the result of the legislation Parliament passed, the so-called Good Samaritan Bill, you're saying that by bringing in Bill C-45, that would then, the protection of the Good Samaritan Bill would no longer apply to someone who was in illegal public possession of more than 30 grams under the Good Samaritan Bill. That's why it's necessary to put it in this bill. Because my question is, why wouldn't they have the protection of the Good Samaritan legislation? I think Dr. Hilson was getting at it with a schedule, but can you explain that?
Well, the Good Samaritan Drug Overdose Act was a change to the Controlled Drugs and Substances Act. When this bill passes, cannabis is removed from the schedules of that act. So the exemption that is available was available in that act refers specifically to drugs that are on the schedule. So cannabis is no longer on the schedule, so it no longer would provide the exemption. So the point is if they're holding whatever they're holding, we don't want them to be afraid to call. Whether they think they're in violation of the law, whether they're holding 40 grams or 50 grams or a kilo, they should be able to make that call, because otherwise people are going to die.
Mr. Van Kesteren.
I don't want to belabor the point, but in essence, what I'm hearing, Dr. Olofsson and Mr. Davies as well, too, that you can OD, because let's face it, Mr. McKenna, that bill was put into effect to protect those that could be charged with drug possession. And so since this is no longer under that umbrella, we're going to put it in here. But I think the record should show, and I think Mr. Olofsson did say that, Mr. Davies, and I think you're correct, that a person could have an overdose, however you determine that, or define an overdose, from the use of marijuana. Am I correct? That was my question.
Not a fatal one.
Okay.
Okay, Mr. Davies.
One quick question from our legislative council. I'm just wondering if this is within the scope of this bill, or whether it would be more appropriately handled by an amendment to the Good Samaritan legislation. Like, is this proposed amendment to provide an exemption in Good Samaritan within the scope of this bill, in your opinion?
Yeah, go ahead.
Yes, we believe it is. Yep.
All right, seeing no further comments, all in favor of new clause 8.1? All in favor?
Could I have a recorded vote?
Beg your pardon?
Could I have a recorded vote, please?
Sure.
Monsieur Ayoub? Mr. Yolson?
Yes.
Mr. McKinnon? Mr. Oliver?
Yes.
Ms. Sidhu? Ms. Gladue?
No.
Mr. Van Kesteren? Mr. Weber? Mr. Davies?
Yes.
Yes pour 6, nays contre 3, 3.
New clause 8.1 is carried. Now, we move on to clause 9, and we have several proposed amendments here. The first one is proposed by Ms. May, PV 2. Any debate on PV2? Ms. Gladue.
Yeah, same comment as before. She's trying to change the amount that the young person can have from 5 grams, which I think needs to be 0, to 30 grams. The other thing I would say is we're going to spend a lot of time discussing proposals from Ms. May, but she did not attend any of the testimony at the committee, which is unfortunate. So just wanted to make that comment.
Any other speakers on this motion? All in favor of PV2? All in favor? All opposed? Motion negatived. All right, PV3. Any debate? Yes, Mr. Davies.
Sorry, this is, I have this identified as Green Amendment 3. Is this to amend Section 9.3?
Clause 9, amended by deleting lines 4 to 15 on page 9.
Well, if I could speak to this, I haven't had the benefit of hearing Ms. May's argument as to why she proposed this amendment, so I'm just left with my speculation. When I read the amendment, the current section says that it's not a defense to a charge arising out of the contravention of this section that the accused believed that the individual referred to in the subparagraph was 18 years of age or older, unless the accused took reasonable steps to ascertain the individual's age. Now, we're still talking about the distribution section where it is possible for someone 19 years of age to sell a joint to someone 17 years of age and be liable to imprisonment up to 14 years, which I will speak to in a moment as to what I will argue is the complete disproportion of that provision. But because of that possibility, I'm going to speak in favor of this amendment because what it does is it says that it doesn't matter if the accused believed that the person they were selling to was over 18, unless they took reasonable steps to ascertain the individual's age, which about the only way you can take a reasonable step to ascertain someone's age, I guess, is to ask for ID. So, but I think it's pretty unrealistic at a party, some party that young people are at, for a 19-year-old who wants to sell a joint for $5 to another person, say, can you show me some ID? I think that's unrealistic. I think that it should be a defense to a charge arising under this section that the accused believed that the person was under 18. And I think that question should be left to the discretion of the judge and the courts to determine whether that was reasonable in the circumstances. If the court finds that they didn't think that was reasonable to believe, then they'll convict them. But if they find that someone reasonably believed someone was over the age of 18 and maybe didn't take a reasonable step to ascertain that, which again is beyond me exactly what that would consist of, then they may acquit. But to absolutely strip a defense from someone that they reasonably believed someone was over the age of 18, I think is it's essentially adjudicating by Parliament, and I think that's too narrow. I think it's enough to say that it's an offence to sell to someone under 18, and I don't think we should strip a defence from someone. So I would vote in favour of this amendment.
I would like to say, too, Ms. May is under the weather. She intended to be here, but she's not able to be here because of that to help us with that. Mr. McKinnon.
I'm going to oppose this amendment. I'd like to respond to Mr. Davies' comments that, how can a person reasonably believe that a person is of a given age if he took no reasonable steps to find out? I mean, what is reasonable in the circumstances is going to depend on the circumstances. But first of all, selling a joint at a party is already illegal. But secondly, I mean, you have to be responsible for what you do, and if you're giving drugs to someone at a party, you should have a pretty good idea how old they are, and if you don't, then you shouldn't be doing it.
Okay, seeing no further speakers, I'm going to call for a vote on PV3.
Mr. Chair, can I just have a brief response?
Why, sure.
Thank you. That's it's in keeping, I think, with the fact this committee didn't hear from a single 16 to 24-year-old that some people our age are discussing what's reasonable or not currently with 19 and 20-year-olds and 18-year-olds and 17-year-olds at parties. And it's well and good, Mr. McKinnon, sort of take that really, tough love, hardcore approach. But here's the reality of parties. They're probably all drinking. You might have a 19-year-old that's had 4 beer, and there may be someone who, someone who looks much older than 17 or much older than 18, but is actually 17 and a half. They may say, come on, I don't have my ID here. There's peer pressure that goes on. And what I'm saying is you really want to subject that person in that circumstance up to 14 years in prison? I mean, with some sort of hard moralizing judgment? I mean, all this amendment does is it leaves the defense open and a judge can make that ruling. But so in other words, I say it should be a defense that the accused believed that someone was over 18 years of age. And if they can satisfy a judge of that, then that should be left open to that in the system. But it's a huge gap, in my opinion, of this entire committee study of this bill that we didn't hear from anybody under the age of 30. And maybe if we had, well, certainly we did in 16 to 24. And, although there was a heck of a lot of testimony about how important that group is and how important it is that we know how to communicate with them, nobody thought to ask one. So maybe we could have asked those people, how reasonable or not is it to have a section like this, when a 19-year-old's dealing with a 17-year-old. Maybe that would have helped inform this committee. But from what I can remember of high school is hammering a 19-year-old with a jail sentence for distributing marijuana to someone 17 and not even allowing them the defense of saying that they believed the person was over 18. Maybe they had friends around that said, oh, they're 18, I know them. Maybe your best friend vouched for them. There's all sorts of things that could lead to your reasonable belief that the person's over 18. I just don't think we should take that defense away.
Okay, thank you very much. Now I'm going to call for a vote on PV3. All in favor of PV, are you speaking or voting?
Just a quick reaction to that. So I think we're missing the fact that the provinces and territories can also step into this space and pass their own laws and their own consequences for the age brackets that they decide should not be in possession and on that threshold. And I think it's possible that we could see provincial charges rather than federal charges. So I do think there's some discretion in here that we have yet to see emerge from the provinces and territories. As I think, again, we're in the early stages of implementation. We don't know yet how the PTs will respond to the legislation. So I do think that the worst case scenario that Mr. Davies paints, I don't think is. I think we'll see alternatives come to bear to give more discretion to police officers in the future.
One very quick comment.
Well, I don't intervene, Mr. Chair, because with great respect to my colleague, I don't think that's correct in this case. The bill does delegate some authority to the provinces to make changes, but not in this section. This section says it is not a defense to a charge arising out of the contravention of subparagraph 1A1 that the accused believed that the individual referred to in that subparagraph was 18 years of age or older, unless the accused took reasonable steps to ascertain the individual's age. I'm sorry, but I don't see in any way how a province can change that in any way whatsoever. I mean, and even if the provinces made the legal age of consumption 19 or 20, it wouldn't change this section. And even if it did, I would say that it makes my argument even stronger, because now you'd have to show that, you know, it wouldn't be a defense to say, well, I thought they were over 19. So I respect that people may want to vote against this amendment, but I don't think that they should vote on the basis that they think a province can fix this section, because I don't think that's the case.
Thank you very much for that. Now, all in favor of amendment PV3, all in favor? Surely.
Monsieur Ayoub.
Je ne suis pas en faveur, donc non.
I'm not in favor, so no.
No.
Mr. McKinnon.
No.
Mr. Oliver. Miss Sidhu. Miss Gladue.
No.
Mr. Van Kesteren. Mr. Weber. Mr. Davies.
Yes. I vote in favor.
Yes pour 1, nays contre 8, 8.
Amendment defeated. All right, now we go to PV4. Any discussion on PV4? Mr. Davies.
Well, Mr. Chair, I'm just wondering, I thought Ms. May would be here and to speak to her motion. I'm wondering, it would be helpful if someone could kind of characterize what the motion was on this one. Can we ask the clerk to do that, or one of the analysts to describe briefly what the amendment is? Is that in
Anybody want to
in order?
volunteer? Nobody, it's hard to speak on behalf of Ms. May, 'cause we don't know what she was thinking or what her thought was. I mean, it really, we couldn't. So we just have to go. I mean, it's unfortunate that she's not here, and I'm sure she feels strongly about these, and we all know the work she puts into it, but we have to carry on. So, all those in favor of PV4, all in favor? All opposed? Amendment defeated. NDP 5. And it says here, if adopted PV5, NDP 6 and NDP 7 cannot be moved, just for your note. So, Mr. Davies, would you like to?
Thank you, Mr. Chair. So this amendment deals with the punishment sections over the distribution offenses, which are in Section 9. So Section 9 prohibits an individual who is 18 years of age or older to distribute cannabis to more than 30 grams. or to distribute cannabis to an individual who is under 18 years of age, or to distribute cannabis to an organization, or to distribute cannabis that they know is illicit cannabis. It's also an offense for a young person to distribute cannabis more than 5 grams of dried cannabis, or for an individual to distribute 1 or more cannabis plants that are budding or flowering, or to distribute more than 4 cannabis plants that are not budding or flowering. And so the section that I'm going to propose we amend has to do with the punishment for the violations of those sections. And what I propose to do, as I have consistently so far, is to replace the criminal penalties with monetary fines, or at least to put limited criminal sanctions to narrow circumstances, and to make the maximum penalty no more than 2 years less a day. As we all know, 2 years less a day subjects a person to incarceration in a provincial institution, not a federal one. Basically, I think that the rationale that I would have for this is similar to what I've already expressed, so I won't belabor the point, but I would just again point out that making it a criminal offense for, say, a 19-year-old to distribute cannabis to a 17-year-old, or in the case of a young person who has more than 5 grams, to subject them to criminal provisions which are under the what's the act called? The Youth Criminal Justice Act, thank you, maintains a criminalized approach to cannabis that we know doesn't work, and that we know will cause more harm than the cannabis itself. So I'm going to, this amendment would replace lines 20 and 21 with fines of not more than $300,000 or imprisonment for a term of not more than 2 years less a day, or both. That's for the most serious repetitive crime. And then replacing for the most common offenses and infractions that we'll see, for a first offense to a fine of not more than $3,000, and for any subsequent offense to a fine of not more than $50,000. And then the same approach for lines 9 to 12, a first offense of a fine of $3,000 and a subsequent offense not more than $50,000, so that there's no criminal penalty or jailing of people for offending these, except in the most serious case or in the most repetitive case.
Mr. Van Kesteren.
Thank you, Chair. And I wonder if we could just ask the officials if they could give us currently what is the punishment for selling, well, I guess it wouldn't be in place, but do any of these I guess I want to compare this to what we currently have on the books for possession, what we currently have on the books for selling to a minor. I suspect whether or not there is even any legislation that would follow that. But if you could just give us, a lot of this looks pretty extreme. Is this in line with what the current laws have on the books, Mr. Des?
I think I may be able to assist you on this. Currently, there's no breakdown of or distinction made between distribution and selling. We have in the CDSA a generic trafficking offense, which includes the distribution and includes selling, and those penalties are high. They're a life maximum. And in amounts that are over 3 kilograms or more, and for over 3 kilograms, 3 kilograms or less, the penalty is 5 years less a day, and those are presently the range of penalties that are available for trafficking in cannabis.
Okay, Mr. Oliver.
Thank you, and I did want to thank my colleague for his comments, and I'm somewhat sympathetic to it. I do have to come back to the stated purpose of the bill, which is to deter criminal activity by imposing serious criminal penalties. I think these amendments actually thwart that purpose of the bill they restrict the court's ability to deal more appropriately with cases involving individuals who distribute or possess for purpose of distribution serious quantities of cannabis, and I think this allows the courts to then act accordingly. So I wouldn't support the amendment.
Okay, seeing no further speakers, I'm going to call for a vote. All in favor?
Have a recorded vote, Mr. Chair, please.
Shortly.
Monsieur Ayou? No. Mr. Yolson?
No.
Mr. McKinnon?
No.
Mr. Oliver? Ms. Sidhu? Ms. Gladue?
No.
Mr. Van Kesteren? Mr. Weber? Mr. Davies?
Yes.
Yes pour 1, nays contre 8, 8.
I declare the motion defeated, or the amendment defeated. Now we go to PV5, another motion or amendment proposed by Ms. May. Any debate on PV5? All right, I'll call for a vote on PV5. All in favor of PV5? All in favor? All opposed? Amendment defeated. Now we go to NDP 6. And it's, my notes here say if adopted, NDP 7 cannot be moved. So, any comments or any debate on NDP 5? 6, excuse me, NDP 6, yep. Mr. Davies.
Thank you. Well, again, this is the mid-level proposal to try to get the criminalized sanctions in this bill down to a reasonable proportional basis. This amendment would reduce the reference to 14 years maximum imprisonment down to 2 years less a day, and for offenses that are less than that to replace all of the indictable the proceedings by indictment, to replace those with summary conviction only. In my view, this loses the advantage that I just expressed in the previous defeated amendment of using financial penalties instead of criminal sanctions. But in lieu of that, it does bring the criminal sanctions down to a reasonable level and in line with what not only what the courts are handing out today in terms of sentencing, but also a similar approach to the regulation of tobacco and alcohol.
Any further comments on NDP 6? All right, I'm going to call for a vote on NDP 6. All in favor of the amendment? NDP 6. All in favor? All opposed? Recorded vote.
Monsieur Ayou? No. Mr. Yolson?
No.
Mr. McKinnon? No. Ms. Sidhu? Mr. Oliver? Ms. Gladue?
No.
Mr. Van Kesteren? Mr. Weber? No. Mr. Davies?
Yes.
Yes pour 1, nays contre 8, 8.
All right, NDP 6 is defeated. NDP 7, any debate? Mr. Davies.
Very briefly, Mr. Chair. So again, because current law in Canada is if there's a sentence of over 10 years as a maximum penalty, a judge does not have the discretion to impose a conditional sentence. The proposal here is to reduce the 14-year maximum sentence to 9 years for the sole purpose to allow a judge to give a conditional sentence. This would reduce incarceration rates in this country in appropriate cases, and it would provide for judicial discretion. Now, I know that the Liberals, I believe, voted against the legislation introduced by the previous Conservative government to take away the conditional sentencing options from judges for sentences over 10 years or more. And by the way, it's not for sentences over 10 years, it's any section of the criminal code where the maximum potential penalty is more than 10. Automatically, the judge loses the discretion to give a conditional sentence. So given, I think, the shared belief by the Liberals and the New Democrats that judges should have the discretion to impose conditional sentences, then I would imagine that we'd want to do that in this section here. So that's the spirit behind my moving. 14 years is arbitrary. I mean, does anybody really expect anybody getting 14-year sentences for, distributing 50 grams or 100 grams of cannabis to someone else. I doubt it. So you may as well make the number. And by the way, we also heard that nobody's getting 9 years for trafficking anyway. They're getting 18 months and 2 years anyway. So why not make this section under the 10-year limit so we can actually cure that deficiency of the conditional sentencing shackles that are currently placed on judges in this country. So I would hope that I get support particularly from my Liberal colleagues, to reduce the 14 years to 9 years, or at least hear a cogent argument as to why not.
Seeing no speakers, call for a vote on NDP 7. All in favor of
A recorded vote, Mr. Chair, please.
vote.
Monsieur Ayoub. Mr. Yolfson.
No.
Mr. McCannon.
No.
Mr. Oliver. No. Ms. Sidhu. Ms. Gladue.
No.
Mr. Verkasteren. Mr. Weber.
No.
Mr. Davies.
Spirited yes.
Yes, close.
Yes pour 1, nays contre 8, 8.
I declare NDP 7 defeated. Now, shall Clause 9 carry? Any debate on Clause 9? Or is that are you speaking? Just voted. Shall all in favor of Clause 9 carry? All opposed? What is it?
So it's a show of hands, so it's
Yes, but you had a count there, did you? Just
not for a show of hands, but 5-4.
okay. All right, Clause 9 carried. All right, now we go to page 3. 23 pages to go. Now we are on Clause 10. All right, we have PV 6 by Ms. May. Any debate or discussion on PV 6? I see no discussion. I call for a vote on PV 6. All in favor of PV 6? All in favor? All opposed? PV 6 is defeated. All right, now we go to PV 7. And if this is adopted, NDP 8, PV 8, NDP 9, and NDP 10 cannot be moved. So PV 7, any debate on PV 7? Seeing no debate, we will call for a vote. All in favor of PV 7? All opposed to PV 7? Amendment defeated. NDP 8, and again, if adopted, PV 8, NDP 9, and NDP 10 cannot be moved. So, Mr. Davies, NDP 8.
Thank you, Mr. Chair. Well, I'm not going to repeat most of the arguments I've made already, but this is, again, an attempt by the New Democrats to take out the criminalized approach to cannabis and replace it with a regulatory system more in keeping with tobacco and alcohol. But I would just mention a couple of new points that I haven't mentioned yet, and that is we heard a lot of evidence before this committee of the very harmful effects of criminalization of cannabis on certain specific groups in this country, notably marginalized groups, racialized groups, and Indigenous Canadians, and young Canadians. Those are the groups that tend to bear the brunt of a criminalized approach to cannabis. And the second point that I want to emphasize is the overwhelming evidence from the sociologists that have studied this issue that most of the harm that is imparted upon Canadian citizens in this country does not come from ingesting cannabis itself. It comes from the harms associated with the criminalized nature of it. And so I think those are important points to mention as reasons that should cause parliamentarians to choose a rational regulatory approach to cannabis and try to avoid criminalizing this substance where we can. Just like alcohol and tobacco, I think we can construct a regulatory regime where Canadians respect the basic rules around these adult use substances that have impacts on people, but without doing it with the heavy hand of the criminal law. So this amendment is to replace the criminalized approach with a regulatory fine-based one.
Thank you very much. Seeing no further debate, I call for vote on NDP 8. All in favor?
Could I please have a recorded vote?
Surely.
Monsieur Ayoub? No. Mr. Wilson?
No.
Mr. McKinnon?
No.
Mr. Oliver? Ms. Sidhu? Ms. Gladue? Mr. Van Kensteren? Mr. Weber? Mr. Davies?
Yes.
Yes pour 1, nays contre 8, 8.
I declare NDP 8 defeated. All right, we're going to go to PV 8. Again, motion or amendment proposed by Ms. May. Any discussion on PV 8? All right, I'm going to call for a vote. All in favor of PV 8, show of hands. All opposed? Okay, motion defeated. Now we come to NDP 9, and again, if adopted, NDP 10 cannot be moved. Mr. Davies.
Well, again, now, if we can't move from a criminalized approach to cannabis to a regulated one, then at the very least, I think we should be putting in reasonable and proportionate criminal law sanctions, and this amendment would do so by replacing the criminal jail sentences of more than 2 years, in some cases 5 years or 14 years, with 2 years less a day, and to proceed by summary conviction only, not by indictment.
Seeing no further comment, I call for a vote on NDP 9.
Recorded vote, please.
Monsieur Ayoub? Mr. Yolson?
No.
Mr. McKinnon?
No.
Mr. Oliver?
No.
Ms. Sidhu? Ms. Gladue?
No.
Mr. Van Kesteren? Mr. Weber?
No.
Mr. Davies?
Yes.
Yes pour 1, nays contre 8, 8.
I declare NDP 9 defeated. Now we go to NDP 10. Any comments or discussion? Mr. Davies.
Thank you. Again, this is the last attempt to try to amend the 14-year jail sentence with something that would permit the imposition of a conditional sentence and an appropriate sentence by a judge. So I would move that we amend this section to have a maximum 14-year penalty to 9. And a recorded vote.
See no more comments, so we'll have a vote on NDP 10. Mr. Clerk?
Monsieur Ayoub?
No.
Mr. Yolson?
Yep.
Mr. McKinnon?
No.
Mr. Oliver?
No.
Ms. Sidhu? Ms. Gladue?
No.
Mr. Van Kesteren? Mr. Weber?
No.
Mr. Davies?
Yes.
Yes pour 1, nays contre 8, 8.
I declare NDP 10 defeated. All right, now, shall Clause 10 carry with no amendments? All in favor of Clause 10? All in favor? All opposed? Clause 10 is carried. All right, now we go to Clause 11, and we have PV 9, again, a move by Ms. May, proposed by Ms. May. Any discussion on PV 9? This is Clause 11. Mr. Davies.
Yeah, I don't know if it speaks exactly to the amendment, but on Clause 11, we didn't hear a lot of evidence about this, but this is a section that says, unless authorized under this Act, the importation or exportation of cannabis is prohibited. And, I think it's, from the New Democrats' point of view, and I think the Conservatives as well, the fact that the Liberals limited evidence on this groundbreaking, centuries-old, changing legislation to 5 days of hearing, and to those who may be listening, saying that there's 90 witnesses sounds like a lot of witnesses, but when you got 35 million Canadians and many groups and stakeholders that were shut out of testifying for this committee, including ordinary Canadians and young Canadians and licensed producers and edibles manufacturers, of whom we heard from none, it leaves gaping holes in this legislation and sections of this act that we're left without any testimony at all. And I've been wondering since those days of hearing about what the rationale behind prohibiting exportation of cannabis and cannabis products would be. In my research for this, I have talked to licensed producers who have licenses from the federal government, distributors who distribute in British Columbia, licensed dispensaries. I've talked to manufacturers. We had a number of excellent witnesses testify before this committee who have decades of experience in cannabis products and also in the medicinal use of it and also in the different products that go along with it, the creams, the tinctures, the sublingual tablets, the nasal sprays, the vaporizer pens for those that don't want to smoke. And they tell me that there's billions and billions of dollars at stake for Canada to become a world leader in responsible cannabis products. And they tell me that Canada right now, if we do get our legislation right, should be able to export our responsible and research-based products, certainly to countries or jurisdictions that have legalized. We know that Uruguay has. We know Portugal has decriminalized all drugs, although I'm not sure that I understand exactly what they've done. Once California legalizes, cannabis will be legal from the Mexican border to the Arctic Circle, really everywhere but the border between BC and Washington. And yet, we are hamstringing what could be a sustainable, science-based, very lucrative, innovative, technologically driven industry, and we're saying Canada can't export any of that to the world. Now, again, I wish we would have heard a single witness who could have testified what the rationale of this prohibition is and why it's considered a wise course of action. I didn't hear any, so I'm left only with my own experience talking to people who tell me that we're actually risking Canadian entrepreneurs and Canadian industrial technology's current advantage in the world. Surely other jurisdictions in the world are not far behind Canada and will be starting to develop cannabis products that are safe, that are properly dosed, that are legal either for medicinal use or otherwise. And so, to me, I don't know if anybody from the department can maybe speak to why we are in this bill banning the exportation of cannabis. I'd like to know if there's any thoughts on that. At least to willing jurisdictions, other jurisdictions that would legalize it.
Yeah, thank you, Mr. Chair. And what I'll point out is that the part one of the bill kind of sets out these prohibitions, and as you noted, the beginning of the clause begins with "unless authorized under the Act." So it's part 3 of the Act, which would actually provide the minister with the authority to authorize both the export and import of cannabis. And it's actually set out in Clause 62, Sub 2, where the minister's discretion or the minister's authority to issue those license or permits is limited to cannabis in respect of medical or scientific purposes or in respect of industrial hemp. And so that would maintain the status quo as it exists today under the CDSA, where licensed producers or Canadian industrial hemp producers can be authorized to export their product to other countries.
Can I ask a follow-up question? Thank you for that. So you said it maintains the status quo, so I take it that the legislation still would prohibit the export of any kind of recreational cannabis that's contemplated by this bill?
That's correct. The minister's authority is limited by that clause I just mentioned,
right,
to only medical, scientific, or industrial hemp purposes.
Right. I guess so. My question, though, is why is that the case? Because I know this legislation only deals with recreational cannabis. So why would we not be able to export recreational cannabis or cannabis products to other jurisdictions that have also legalized it?
So I understand the question, Mr. Chair, but as an official, I can't really explain the government's reasoning in making that decision, only to point out that that's the way the legislation is currently drafted.
Thank you. Thanks.
Okay, Ms. Gladue.
Thank you, Chair. I agree with my NDP colleague that I was very concerned we didn't hear testimony, especially from places like Uruguay, which was the only other country to have legalized. And understanding, what they did in this area might indeed be very helpful. But I know with 272 days left to go, the Liberals are in quite a hurry to get through this. My question has to do with the medical marijuana export. I happen to have a company that does export to, I believe, 9 countries. But as I understand it, under the current treaties that we've signed with the UN, there's a limit to the amount that Canada as a nation is allowed to export. And so will they bump up against that in terms of this legislation?
So thank you again for the question, Mr. Chair. I can't speak specifically to what you're saying under the Access to Cannabis for Medical Purposes regulations. If what you're saying is in fact accurate, and we can endeavor to provide an answer. What I can say is that under the Cannabis Act, if it's enacted by Parliament, a new framework would be established in regulations that would deal with the import and export process, and so that's to be decided by government, I would say.
Okay. Who was Mr. Oh, Ms. LaBelle, yes.
To add to that response, under the drug conventions, Canada is required to report the amounts of cannabis that are used and sold for medical purposes. And that is an aspect we don't expect to change. Whether it actually creates a ceiling as to how much can be exported is up for question.
Okay. Mr. Van Kesteren.
Chair. I just want to say in the outset that, Mr. Davies, I commend you for your advocacy of attacking the premise that if this is a legitimate drug, if this is legislation that is purposeful, if this is legislation that is good for society, and you firmly believe that, and I respect that, then the heavy-handedness that we're seeing from the government is really hard to understand. We've had some discussion with some of the officials about how we deal with other countries, and in my motion, I would argue that the most important part of that motion is this is big. This is going to change us fundamentally as a society. And there are groups out there. I'm talking about moms and dads with kids in school. I'm talking about surgeons and physicians that have some serious concerns. But there also are groups outside of our jurisdiction. And I'm curious if the officials, we mentioned Paraguay as a nation, and it's often held as an example of a jurisdiction that has adopted these. And from the research that I've done, there's very, it's very slim at best to suggest that this is at all like what we're proposing in this country. The Netherlands, where my parents come from, that had a very relaxed set of laws for are reverting. They're going back to another position. So I want to ask the officials: do you feel that we've done enough? And again, in light of the fact that this legislation will be passed and will be enacted in July of 2018, have we done enough? Have we searched and have we communicated to other jurisdictions? Have we looked at other jurisdictions? I would suspect that they're really this is cutting edge, but have we, in light of the importance of this legislation, have we really done enough to make an educated decision on this legislation? I invite anybody to respond. Mr. Costa.
So thank you, Mr. Chair. I'd be happy to do my best to answer the member's question. We've, as officials, have benefited greatly from conversations with our counterparts in jurisdictions
not only in the U.S. states, but in the Uruguayan government. Having been in the role that I'm in for a number of years now, I can say that we've, I think, developed what would be fairly described as some fairly strong relationships into all of those jurisdictions, so that we can understand the issues that they're working through and benefit as much as possible from the lessons that they're willing to share with us. It may be of interest to the member. I just recently returned from Portland, Oregon last week, where there was a meeting of all of the heads of the regulatory programs in the U.S. states for the very purpose that you're describing, where we can discuss the issues, share lessons learned. And so I believe that Canada is listening very closely.
Just a quick follow-up. Have you done, Mr. Costin, have you had discussion with, for instance, with physicians? Have you, in those jurisdictions, have you had discussions with soccer moms? Have you had discussions with the police?
So we've had discussions primarily with government representatives, but that would also include law enforcement.
Have you had discussions with physicians?
Also members from the healthcare community in those jurisdictions as well, yes.
And you've reported on that as well, too?
Pardon me?
You've reported on that as well, too?
I've reported?
Do we have the information that we can glean from their testimony and their responses as to?
I can really only speak to what the meetings that I've been at and the presentations that I've heard and the discussions that I've been part of, and perhaps also that the task force in their report also reflected on. I understand they also visited those jurisdictions and had conversations with a wide range of individuals.
I think we have Mr. Davies next, and if we could confine it to the amendment, we're kind of getting off base here. I want to point out to Uruguay, the fact that we didn't have anybody from Uruguay has come up a couple of times here, and we had over 100 witnesses, and all of the names were submitted by all of the parties, and nobody submitted a name from Uruguay. No party did. So I just want to make that clear. Mr. Davies.
Thank you. Well. Yeah, I'm just going to continue speaking about the importing, exporting, because that's section 11 here, and we're talking about the punishments for violating that. Just a few things I think are important to put before colleagues here at this table here. And one of them is that I talked to a licensed producer, a very large licensed producer who's producing for the medicinal market now, who told me that their company is contacted every week by a foreign business or foreign jurisdiction that wants to learn from them or go into business with them or partner with them. And I'm reminded of Kirk Tusaw's testimony where he looked pointedly at the committee and he said, you know, you politicians are talking like you're creating a market. You're not creating a market. He said, the market exists. There's a $7 to $10 billion market in Canada right now, regardless of what we do. And so what we're really doing by this legislation is we're trying to modernize the regulatory frame, and I congratulate the government on taking steps towards this, because we're trying to take that illicit market into the light. And we're trying to recognize that not only can we shed the harms of criminalization, but we actually can regulate it properly and make this a legitimate business. You know, we export spirits and wines in this country. We're all proud of Canadian wines that have a global reputation as we're sending that around the world. In fact, I think the Conservatives have taken the lead on showing the problems we have with overly restrictive transportation of beer across borders. We can't even buy beer in one province and take it across. So in my view, and maybe the Conservatives don't necessarily share this perspective, to me the trend on cannabis is we're moving towards ever more legalization. And Canada being a leader in that regard, getting ahead of the curve, I think would position us well. We have to remember that in Washington, in Oregon, in Colorado, that they legalized cannabis by citizens' initiative. This is what the people wanted. And I think actually in many cases the populations are ahead of the politicians on this. And I think the world is moving in this direction. So you know, that's why I think that what I'm hearing from the market and the business people who are involved in this is that if we regulate this properly and move forward, Canada can actually not only legalize and legitimize the illegal market here in Canada and create tax revenues and get healthier and save our justice system a lot of grief, but actually we can position Canada to actually be a leader in a very lucrative and growing product on the world stage. And I just want to conclude by saying, Mr. Van Kesteren, I don't say that it's good necessarily. I say cannabis is what cannabis is. It is an adult use substance that alters consciousness. It also has significant medicinal advantages that are beyond doubt. I just think that it's a product that adults use, whether we want them to or not, and the criminalized approach is simply not an appropriate way to regulate that substance any longer. So that's why I'd like to see this legislation changed, and I'm going to move that Section 11(1) be amended to allow the minister to make regulations that would permit the exportation of cannabis covered by this act. I don't know if I can, if you want language on that right now, or if the concept is good enough. Perhaps I'll draft it for tomorrow morning.
Yeah, that would be really good, because we've got, let's finish up with PV9. I was just thinking Elizabeth May would be proud of us, because we spent a lot of time on her two-line amendment.
Well, actually, I'm talking about 11(1), Mr. Chair. It's not her amendment.
But we're on PV9 at the moment. So that's what this debate is about. So I want to bring Mr. Oliver. I want to bring PV9 to a vote. We're at 5:30 now, so if we can get a decision on PV9, all in favor of Amendment PV9? All in favor? All opposed? All right, PV9 is defeated, and we are going to suspend there until tomorrow at 9 o'clock. Where are we tomorrow?
Center Block.
We're at Center Block tomorrow.
Are we breaking for question period tomorrow, or are we going straight through?
What is the will of the committee? I think we did say we would just, yeah.
We said we would break for QP.
It depends if you have any questions.
I have an SO31 on mental health, so as the health committee, we should want to be there for that.
All right, meeting suspended.